Welcome back to the county seat. Last December, Ken Salazar, Secretary of the Interior, passed Executive Order number 3310, which called for a reinventory of all the BLM lands across the nation to see if there was any more that would qualify for wilderness, and then manage it as if it were wilderness until Congress could decide what to do with it. Only problem is, that's the same thing they did with wilderness study areas 25 years before, and to date, the Congress really hasn't done very much with any of that either. This has the state of Utah and the counties in Utah very concerned. They're not happy about it, and they've passed a new bill and put it into effect called Senate Bill 221, the Utah Resource Management Plan for Federal Lands. So the next question is, Susan Wood, what is it?
Well, Chad, east is east and west is west, a simple phrase that implies an underlying difference between the two geographic areas. In the U.S., there is definitely truth to that. The east and the west are different, not just in architecture and history, but in how they are managed on a federal level. The eastern half of the United States has very little public land, while in the west, huge tracts of federally owned terrain stretch off into the distance. That isn't necessarily a bad thing for states like Utah when management officials in Washington and local leaders see eye to eye. Smiles and handshakes aren't always the end result, though, and much to the frustration of county and state leaders, federal mandates often conflict with local ideals. In an effort to bring federal land management policies more in line with county and state planning, the Utah State Senate passed Bill 221, a piece of legislation that poses a challenge that could go all the way to the Supreme Court.
221 was to put in statute all of the things that we think should be in our planning ordinances for the state of Utah to show the federal government that yes, we do have some say in these plans, more than just what others across the country do, because it is our state and we are dependent upon the federal government following through on their plans and policies and on the laws that they created, which allows us to still continue to use these public lands.
This bill takes advantage of a long-standing rule in federal law that says BLM managers must adhere to state and local plans for managing BLM lands, must be consistent with those plans to the maximum extent while not being inconsistent with federal law.
Senate Bill 221 catalogs all of the basic uses for public land in Utah, including cattle grazing, water rights, vegetation, recreation, and wilderness. The bill states that public lands not already designated for other purposes should be managed with a multiple use mandate and respect for local concerns, forcing federal managers to follow what is already known in the Federal Lands Policy Management Act as the Consistency Agreement. This clause states that land plans from the national level need to conform to local designs. The road to passage of SB221 began just last December in response to wildlands, a designation similar to the current wilderness title given to lands that are closed off to any human presence beyond hiking. That potential expansion of wilderness has caused many counties alarm.
This wildlands designation just really smacks of de facto wilderness, and it has us all concerned, and I know our representatives in Washington are battling against it. And we appreciate the governor and all the efforts he's made, and our representatives who have been very vocal and active in fighting against this designation.
There are legitimate areas that have never been touched by man in this state. Well, you might as well say, yeah, leave in their pristine state. I submit a lot of those are already under wilderness protection.
The challenge to federal authority posed by Senate Bill 221 could have lasting impact on Utah's counties, first and foremost with a legal fight. The legislation might be challenged in federal court and even appealed.
I know the counties will keep going and will take this as far as we have to, even if it means all the way to the U.S. Supreme Court.
Each county will need to update their land use plan so that no details are left out, at which point, according to SB 221, federal management will need to mirror those local uses. West is west, and that means open space, frontier, beauty, and yes, public lands. The question of control will continue to bounce between federal and local, but it may just be the courts that have the final say.
We're united. I don't know of any county in the state that isn't on board with this.
Who is responsible for managing and the control of these public lands? In my mind, first and foremost, it's the people of the state of Utah, because we live here. And we have to be able to access those lands. We have to be able to use the water resources on those lands. We have to be able to use the renewable resources, the timber, the grazing, and the mineral resources on those lands to be able to exist in this state.
It gives the state and the counties a benchmark to say to the BLM, you have to toe the line to this bill because federal law says you do. We have a clear plan, we have a clear standard, and now we're in a position for the courts to tell us, does the law mean anything or doesn't it?
That question will be answered soon enough. For the county seat, I'm Susan Wood.
The Wildlands Initiative has caused quite a bit of stir. As a matter of fact, it has become such an issue that all of the western states have put a little bit of pressure on Congress, and as of the early part of last week, the funding for this fiscal year for the Wildlands Initiative has been taken out. So this won't become an issue until the fiscal calendar for the next year begins. The project is defunded. That's pretty good news for the western states who were opposed to the initiative and the way it was brought about. We will be discussing a state bill, Senate Bill 221. When we come back, our guest will be Mark Ward, who is from the Utah Association of Counties, Senator Ralph Okerlund, who is the sponsor of the bill, and Doug Heaton, Kane County Commissioner. Stay with us for the county seat. We'll be right back in a minute.
Native Americans called it the land of the sleeping rainbow. It's a place of unparalleled enchantment, where history, splendor, and industry meet. We call it Sevier County. Experience the Paiute Trail by ATV. Explore 7 national parks, all within a few hours' drive. Gaze down at the world from an entirely new perspective. Join us in Sevier County and discover real Utah. Come, explore the Paiute Trail and beyond.
The State of Utah School and Institutional Trust Lands Administration. SITLA manages 3.5 million acres of Utah lands with the express purpose of furthering the education of Utah students while promoting local industry, oil and gas, even residential development, all at the same time. Through the careful use of trust lands, we distributed more than $22 million to Utah schools last year. The State of Utah School and Institutional Trust Lands Administration, building the state's permanent school fund.
Almost 45% of the oil produced in Utah, 7.8 million barrels, comes from Duchesne County. That oil feeds our state economy, provides job growth, and supports local business. Here in Duchesne County, we're working to make Utah an economic, cultural, and technological leader. Whether you're here for business or pleasure, Duchesne County will welcome you with open arms and invite you to explore all the beauty of the Uinta Mountains. Duchesne County, close enough for business, far enough to get away.